The first matter to come before us this morning is State of Ohio versus Wayne Harris. The appellee has waived oral argument. You have 15 minutes to present oral argument this morning. We've read the briefs. We're ready to proceed when you are, Counsel.
Thank you very much. May it please the court, I am Alan Medvick. I represent the appellant Wayne Harris in this matter. We have raised one assignment of error regarding the sufficiency of evidence with two distinct issues within that. First, regarding the claim, the charge of obstructing official business, there is insufficient evidence for a finding of guilt on that charge in and of itself. And secondly, even if there was evidence of a affirmative act which hampered any official proceeding, there was no risk of physical harm created by that act. As to the first issue, this is a case where police officers arrived on the scene of a claimed aggravated menacing neighbor fight. At the time, Mr. Harris, the defendant in this case, was in his home. When he began to emerge from his home, the police officer told him to stop and place his hands on his head. The defendant instead retreated back into his house.
Well, he had a gun in his possession at that time.
He did not have a gun on his person. There's no evidence to reflect that. There was a claim that he had a gun earlier in the day.
Okay.
I don't think that there's evidence in the record that would indicate that he had a gun on his person at the time he was leaving the house. I don't believe that's indicated in the record. I think that the gun was found inside Mr. Harris's house after the police gained access and consent to search from Mr. Harris's wife, I believe is what the record indicates.
Well, he had a gun. The neighbor had indicated he had a gun.
Yeah.
On his person.
He showed a gun.
He showed a gun to the neighbor.
Right.
But that was, I'm not disputing the aggravated menacing charge,
Well,
which was charged as a misdemeanor in this case. I'm not.
The only reason I'm saying that is to follow up with Judge Whitmore's question. The police were aware that at one point there was an allegation, at least, that he had a gun.
Yes.
Okay. So they don't know whether he has a gun on his person or not at the time when they first approached him.
No, they do not. But I would indicate that possession of a firearm or the risk of there being a firearm is not an element of the obstructing official business.
No, but it would go to whether or not there's danger or harm or...
What I would indicate, however, though, is,
felony.
as to the second aspect of that, the risk was not created by, the risk of harm was not created by the retreat, by Mr. Harris's retreat into his own home. There was no evidence that Mr. Harris, by closing the door, increased or changed in any way the risk that the officers understood to be the case, which was that there was a firearm at issue in this case. There was no indication that Mr. Harris retreated into the home and picked up the firearm. There was no indication that he barricaded or attempted to set any kind of physical harm, any physical risk to the police officer should they try to enter his home. There was no effort to barricade himself in, no effort to increase the risk to the officers. And when they arrived on the scene, the risk that there was a firearm at play was already there. When Mr. Harris retreated into his home, that risk did not change in any way. The act at issue of refusing to cooperate with the police officer did not increase that harm or that risk of harm in any way.
Both briefs make reference to a discussion with the dispatch, but neither brief actually says what was said and how that impacts the obstruction. I understand from your brief that there was no testimony regarding what was said to the 9/11 operator, for lack of a better designation. But was there some testimony from the deputy about information that he had gained from that, from dispatch?
I think, to the extent that there was testimony, I think the testimony was that, I think there were conflicting 911 calls in this case prior to, or leading to this, to the investigation. I think Mr. Harris, the testimony is that Mr. Harris may have called 911 while inside his home and indicated he did not have a gun in his possession. I think that is disputed as to whether that could be considered a false statement, because I don't believe he had the gun on his person at the time. But to that, I would indicate that to have an obstructing official business charge, you not only have to have an act with the purpose of inhibiting or interfering with an investigation or official process, it has to actually impede in some way. I don't know that the officers were impeded in any way by that information. They did not find a gun on his person. They did not. I don't think they believed or reacted in any way to that 911 call, and the testimony thereof would be. And I don't think that that has been the basis of the finding in the trial court as well. I think we would be trying a different matter to start to consider that here. Additionally, to that point, the retreat into his home also did not present sufficient evidence of any impediment to the investigation at that point. He came out onto the balcony, began speaking with another officer at that time. There was very little that could be pointed to as an actual impediment to the police investigation at that time as a result of him remaining in his home. I would point this court to State versus Crowell, a case out of Lucas County, I believe, 189 Ohio Ave. 3rd, 468, which is a very similar, I apologize, 2nd District, Montgomery County. Very much on point. It is a similar case where a defendant retreated into his home and refused to come out, but was eventually did come out via a balcony to another officer. In that case, there was no finding. And again, there was a 911 call, which may or may not have had misrepresentations contained in that. And that court found no obstruction of official business in that case. That relying on first, that the refusal to leave your home is not an overt act, according to a pretty long line of Ohio cases. That a specific misrepresentation, an act of escape, the mere refusal to cooperate with the police officer's order is not considered an act sufficient for an affirmative act for obstructing official business. That's held in this Crowell case as well. And again, not merely that even if the act was intended to impede, it must also result in an impediment. And again, here, to the second prong and the second issue, while I understand that there was a gun at issue, and that when there is a gun, there is always a heightened concern of harm. The issue here is that the act of the defendant must have caused an increased risk of physical harm.
So if he had retreated and there had been a 24-hour standoff, would you be making the same argument?
If there was a
24-hour
I don't believe that-
standoff, come out, put your hands up, put the gun down. He goes into his house, he's in his house with a gun, and he doesn't comply with the officer who says come out.
If he had affirmatively picked up a firearm and said, "I am armed, do not come into my house," that is where I would probably
That's not
say.
the question I'm asking. He goes into his house, he's known to have a firearm because it was called in as such.
Right.
And he sits in his house and he says, I'm not coming out, and this goes on for 24 hours, are you saying he's not impeding an investigation?
And what I'm saying is that without some affirmative statement that he is armed, that he has increased the risk in any way, I would say yes, that I would agree. If the police officers have no reason to enter the home without a search warrant, I would say that they obtained consent, and
Well,
whether they had a right to
we're going
proceed on
into
executive
speculation,
searches.
thank you.
And I understand.
Can't take any more.
I'm just, to address, I don't believe that a time constraint would necessarily be at issue. I think it's whether there is an affirmative risk of harm that is created. And to that end, I don't see such harm here. I think that the record is barren of such an indication of increased risk of harm, or really of any obstruction of official business. I understand that I'm arguing with an empty chair here, and sometimes that creates a difficulty. I would cede the balance of my time.
Well, before you do that, right, so the empty chair says, if you look at the totality of the circumstances,
Thank you.
you've got this film, you've got this.
I would actually speak to that, because I believe that is, that's not what the law said. I think that would create an ambiguous indictment. You can't simply, the charge is that there has to be an affirmative act. There has to be an act which the defendant performed, which caused an impediment to the investigation.
So the aggravated
argument,
menacing itself can't be that act.
the aggravated menacing itself could not. That actually predated any claim of obstructing official business. The fact that they were there for what was an act of menacing, an argument between neighbors which escalated with the knowledge that there was firearm at risk, I don't think that can't create either the risk at issue for the felony conviction or for the obstruction of official business. There has to be some other separate act after the police were already beginning their investigation, which would have led to this. The heightened atmosphere based on knowledge that there may be a firearm at issue would not be the consideration here. It is strictly the acts of Mr. Harris after the police arrived and his refusal to exit the home. I thank you for your time.
Thank you, counsel. The court will take a matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which can be linked to through the 9th District Court of Appeals website.
Thank you.